We are following up on a theme which we talked about last time, which is workplace monitoring. But rather than looking at what happens when you monitor your employees, we thought we'd turn it around this time, and look at what happens when your employees monitor you. And this is something which increasingly we are coming across as an issue. And I think the reason for that is the obvious ones, which is the ubiquity of mobile phones and the increasing number of devices on a phone, which allow people to do all sorts of weird and wonderful things with them. So, you know, I think the technology within a mobile phone now for actually being able to record voice and film is probably as good as many cameras were 10 years ago, and that's something which we see. I think it's probably also a sign, isn't it, that people just now feel that they live their lives online, and regardless of the fact that privacy is a real concern, everyone just thinks, well, what's the problem? If I want to record something, I'll record it. But I think it makes many people feel quite queasy, the fact that they may be subject to a covert recording, particularly in a disciplinary or grievance meeting, and I think increasingly it's an area of law which we're just starting to look at and we're starting to get to grips with. So I suppose if we were to ask ourselves a question, the question we're trying to answer today is, you know, what can you do if your employee is found to have been covertly recording? What do you say if an employee asks whether or not they can record a particular matter? But I think we're going to focus particularly on that covert aspect of it. So we'll just sort of have a look at that. We'll look at some of the legal issues, and Vanessa's going to go through the cases in this area, and then we'll just pick up data protection, because I think that's a key issue in all of this. As I said, where this tends to come up for us is disciplinary and grievance meetings. Often it can come up quite late in the day with a tribunal claim on the go, and all of a sudden you're getting a call from the other side to say, we've got a recording of that particular disciplinary meeting, we've got a recording of that particular grievance interview, and we want to play it to the tribunal. What do you say? What do you do? Often it can come up with an employee saying, well, I don't want to take a companion, I'd rather have my phone. Yes, my phone is my best friend, and that's who I want in the meeting. So some employees will be upfront about it. I think the other thing which again we tend to see comes up is, and this I think throws up probably more issues in terms of rights, is this idea that actually you've got people walking around with their phones in their pockets, set to record, looking to record conversations with colleagues, either for the purposes of entrapment or presumably just for prurient interest later in the day. So that's the kind of thing which we're dealing with. What does the law look like in this area? Well, it's the same old things, but perhaps in a slightly different way. As I said, we'll look in detail at the Data Protection Act, because I think there's some interesting Data Protection Act details around all this, and how the Data Protection Act and has implemented the GDPR positions on this. Human rights, often in these sessions we're talking about Article 8, which is the right to a private life, and clearly that's engaged. We have a slight issue, which of course is we've also got Article 10, which is all about freedom of expression, and what kind of freedom of expression there is to record. So we'll look at that. Equality Act really comes up in this context because of that issue of entrapment. When you're looking at bullying and harassment investigations, allegations, etc., then I think increasingly what you tend to find, isn't it, Vanessa? You don't get anything sort of very concrete to support an allegation, but actually
it's his word against
exactly
hers, isn't it?
Yes, he said,
or
she said, or
word against his.
yes, and whatever other combination of those you want. But what happens actually if you have got that footage? I think what happens if there looks like there's some evidence of harassment or discrimination? Employment Rights Act, how does this come up when you're looking at disciplinary grievance hearings, etc.? And finally, what happens when it gets to a tribunal? How does it interact with the tribunal rules of evidence, etc.? So there's some of the legal issues. I'm not guaranteeing that we're going to answer all of the questions around those today, because there are an awful lot of questions and actually not an awful lot of legal answers perhaps, but we'll try our best to give you some practical pointers. But it is worth starting, I think, and looking at the cases.
Yeah, absolutely. Yeah, thank you, Matthew. So the first one we're going to look at is Phoenix House and Stockman, and this is actually was a tribunal case that went to the EAT on the issue of compensation in an unfair dismissal claim. But essentially what happened is that the claimant was dismissed by her employer due to a breakdown in the relationship. She brought various claims, including unfair dismissal, whistleblowing, race discrimination, victimisation and breach of contracts, and the actual issues in the case aren't relevant for today. But essentially, during the hearing, it transpired that the employee had made a covert recording of a conversation or a meeting that she'd had with HR. The findings of the tribunal with regards to the claims were that they decided to uphold her claim of unfair dismissal. And they decided to reduce her compensatory award by 10% to basically reflect her conduct in covertly recording this conversation. The respondent, Phoenix House, decided to appeal and said that actually, had it known about this covert recording at the time, they would have dismissed her for gross misconduct. Therefore, she shouldn't receive any compensation at all. So this obviously went to the EAT, and the question was, does a covert recording of a meeting undermine this relationship of mutual trust and confidence? The EAT has commented, as Matthew already has today, is that actually covert recordings now aren't difficult to do, and they're certainly not uncommon anymore. And they're not necessarily done to entrap an employer. There are a variety of reasons that they may be done. They might be simply to keep an accurate record of a meeting. They might be because an employee is trying to prevent a risk of any misrepresentation in their responses to accusations that are put to them. And of course, it might also be to enable an employee to go away and take legal advice after a disciplinary meeting, for example. So actually, in this case, the EAT said, well, actually, the meeting that she recorded actually only concerned herself. It didn't contain, for example, any confidential information about the business, and therefore the tribunal correctly assessed the compensation. But what the EAT continued to do is actually said that the tribunal isn't bound to conclude that a covert recording of a meeting necessarily undermines trust and confidence between the employer and the employee to the extent that they can dismiss as a result. Actually, what a tribunal should do is consider all the circumstances. And so what I've put up there are the circumstances in particular that the tribunal will consider. So why did the employee record the meeting? Is it because they're setting out to entrap their employer? Are they manipulative in that way? Or actually, is it a confused or vulnerable employee feeling that they're like a rabbit caught in the headlights, and they just want to try and keep an accurate record of the meeting to safeguard against any misrepresentations? What has actually been recorded? So going back to the point I made earlier, is it just a meeting that's all about them, the individual, or is it a meeting that's got highly sensitive information about other employees or confidential business information? So obviously there's a very important distinction there. The extent of the employee's blameworthiness. So again, what's the employer's stance on recordings? Is it clear? Which again goes probably actually to the last point there, but does the employee know that recordings shouldn't be made? Has the employee been explicitly told that no recordings are allowed? Have they lied about making a recording? So all of this kind of goes into the mixing point when looking at the employee's conduct and potential misconduct. It is a helpful case because, of course, it gives us some guidance on covert recordings of internal meetings. And the conclusion really is it will amount to misconduct, but actually most probably not gross misconduct. But what this case didn't do was obviously consider any of the data protection or privacy issues, which I know that you will very helpfully come and deal with later on. But it is a very interesting case, actually, I found. And certainly it's one of those ones where your initial gut instinct might be, right, gross misconduct, where's the trust? But actually we need to put the brakes on.
Yeah, absolutely. It's quite interesting that the Employment Appeal Tribunal is prepared to look at a range of factors,
yes,
and not just completely shut the door to this being a something which shouldn't happen.
Yeah. So we're kind of moving on from the misconduct aspects of it to actually going to talk about a few cases about admissibility of such evidence in the tribunal, because I think it's important, and it's important to know actually when you're faced with these situations, would this evidence actually come from the tribunal? Do we need to be more careful in our deliberations that we think are private? So with this case, the employee was a teaching assistant and she was dismissed for misconduct, and she brought an unfair dismissal claim at the tribunal. Her claim centred around the fact that she felt that she'd been unfairly treated throughout her disciplinary process and the appeal process. So each of the hearings, of course, there were minutes taken of the hearings, and then actually in the hearings there were, as per usual, the break in the hearing where the panel goes away and have their private deliberations where they decide what the outcome is going to be. The employee recorded both the disciplinary meeting as well as the private disciplinary deliberations, the private deliberations of the disciplinary panel. Oh, it's a sentence. So the question was, could both of those recordings, or just one, or one of them, be used in evidence at the tribunal? She produced these recordings actually on the first day of the tribunal hearing, which obviously upset the respondent quite a bit. And the tribunal initially said that yes, they could be disclosed and used in evidence. And so the school appealed, and it went to the EAT. So actually, just pausing for a moment, what do the tribunal rules actually say with regards to evidence and what's admissible? Well, put up there what it says, and it says, so far as it appears appropriate to do so, the chairman or tribunal shall seek to avoid formality in their proceedings and shall not be bound by any enactment or rule of law relating to the admissibility of evidence in proceedings before the courts of law. So what does that mean? It means they've got a wide discretion, basically. Tribunals have much wider discretions than your other courts, the High Court, etc. And they've got a wider discretion to determine how they run their proceedings and actually whether evidence is admissible. And our key test whenever we're doing disclosure exercises is, of course, is the evidence relevant to the issues to be decided in the case? And that's how the tribunals decide it. But of course, even if the evidence is relevant, applications can still be made to exclude the evidence. And these are, for example, when evidence is perhaps produced very late in proceedings, because it puts the other party in an unequal footing. If there's any privacy issues, human rights issues, and of course, whether it should be excluded as a matter of public policy, which is, as you'll see, this is where the cases are going. But of course, as I said, the tribunal does have a wide discretion, really, as to how they run their proceedings. So the EAT found that the tribunal actually found that the fact that there were covert recordings doesn't by itself mean that they're unadmissible. The employer appealed on the grounds of public interest, as well as some other points, but basically said that actually it's an unjustified infringement of the right to privacy enjoyed by the governors who were on the disciplinary panel, and that public interest required that private deliberations should remain private. The EAT first of all asked the questions, of course, is the evidence relevant? And the question was answered, yes, the evidence was relevant. So therefore, let's look at the 4 appeal grounds. The first one was procedural unfairness. And basically the tribunal, so the employer tried to argue that because it was brought in on the first day of the hearing, they weren't given enough time to consider it. Well, actually what the tribunal did do is they said, okay, we're going to postpone the hearing. We're going to give a cost order against the claimant for wasted costs of today. So you can go and respondent can go and consider the evidence and then come back. So the EAT found that actually was a fair approach by the tribunal. They then considered human rights, but they actually felt that actually there really wasn't an infringement of the right to privacy here. Whilst they felt that there were going to be private conversations, the governors kind of volunteered to do this role, and actually it's likely that actually their deliberations would become public because of course that decided the outcome of the hearing. And there was no actual evidence of any infringement with private lives. And as we've mentioned before, we also have to consider the other right, which is a right to a fair hearing. and balance
Article 6.
well. Yes. Illegality was briefly considered by the EAT, but they didn't put much weight on this. The covert nature of the recordings didn't in itself mean that they should be excluded. So the real issue was public policy, and this is where the EAT really thought about it and said, look, there are conflicting public policy interests here. On the one hand, there's a clear public policy that claims brought in a tribunal should be heard on all available evidence. On the other side, there's a public interest in parties that are in disciplinary or appeal proceedings that they comply with the ground rules of those hearings, and the understanding that the panel members' conversations would be private was essential if, of course, they'd be able to have this full and frank discussion, as the EAT described it. And this is where they kind of distinguish between these private deliberations and, of course, the actual hearing, where they said, well, there was going to be a record kept of that hearing in any event. So the EAT concluded that the tape recordings of the private deliberation shouldn't be admissible, but of course the recordings of the actual hearing were admissible. And they went on to say that actually the balance between this conflicting public interest might have fallen differently if it was a discrimination claim, and if the decision had been taken by a panel which had given no reasons for how they reached that decision, or where actually the recording of the deliberations gave the only evidence of the possible discrimination, which comes to the point we were talking about earlier, that often it's very hard to find that evidence. And so what this case did is it's kind of set the ground rules, or the general rule, that actually recording of any parts of a meeting where the employee is present going to most probably be admissible, but private conversations or with for public policy reasons wouldn't be admissible. However, as often happens, we then have some other cases which bring exceptions. But before that, we do have one other case that I wanted to talk about, which kind of follows this rule, which is the Vaughan and London Borough of Lewisham and others. I brought this one up because it had 39 hours of secret recordings. I don't even know if your phones could store that amount, but apparently they can back in 2012. And the claimant had been in, I think she was dismissed. And over a course of 2 years, she's made all these recordings, and she brought claims, various claims for discrimination, harassment, unfair dismissal, and also whistleblowing. And so she's actually recorded with a dictaphone, actually. Tell a lie, it wasn't a mobile phone, it was a dictaphone. She didn't provide any copies of the transcripts. At the disclosure point, she kind of said to the other side, I want to disclose all of these recordings. The other side understandably challenged it. It went to the tribunal to consider, and the tribunal was trying to get from the individual, what are these conversations you've recorded? What is the relevance? But unfortunately, the employee at that point didn't really provide much information whatsoever. So the tribunal understandably refused her request to admit them as evidence. The claimant appealed, and of course it then goes to the appeal tribunal. The EAT upheld the tribunal's decision. And the key really, what they said is that she hasn't explained the relevance. Because the tribunal's been unable to actually properly consider the relevance, they couldn't decide to say that they were admissible. And therefore they said that if an employee wants to rely on the evidence, then they need to explain why it's relevant. What actually happened in this case is that the claimant made a fresh application. She narrowed her request, and she actually explained, and I think produced transcripts and explained why it would be relevant. And she was actually permitted to produce 5 of the 39 hours as evidence. So that's quite an interesting one, just purely for me, for the fact that you've got 39 hours of secret recordings.
Yeah, but it happens. I did a case many years ago in Scotland where we had, very late in the day, it transpired that the claimant had been recording, and we had gone through each stage of the disciplinary process: verbal warning, appeal, written warning, appeal, final written warning, appeal, dismissal, appeal, and the grievance. And before you knew it, we took a 3-day hearing. We extended it to over 10 days, just because of the sheer volume of these things. And that is a practical issue. And then it's an issue about actually how you do present them. Often, there's lots of them which can't really hear properly.
Yeah.
Which can be a real problem. People think there's a smoking gun there, but all there is a few muffled sort of noises that can't be interpreted either way. So it's there are some practical difficulties as well.
I think what happened with this one is the tribunal tried to suggest that actually the claimant had to pay for an expert transcriber to produce all the transcripts, and the EAT said no, that's too onerous.
Yeah.
Actually, all the other side needs is the audio recording and a transcript that the claimant could have written, and they have to go through and decide accurate or not accurate.
Yeah, but it's still a hugely onerous process, painful, isn't it?
Very.
Yeah.
So the exceptions to the rules. So this case, again, it concerns an employee who decided to record their disciplinary and grievance hearing, as well as the private discussions of the panel when the employee was out of the room. The private panel comments basically included allegations that the manager or the MD actually had given an instruction to dismiss the employee. And with regards to the grievance hearing, the allegation was that the comments that was recorded basically said that they were the panel was deliberately going to skip some of the grievance points. So the employee wanted to use the tapes as evidence in her tribunal claim. The employer objected to the admissibility of the private discussions based on this public policy argument that we discussed in the Amel School and Doherty case. And the tribunal said actually the comments that were alleged to be made by the panel, because they were well outside the area of legitimate consideration of the matters they were meant to be considering, this case could be distinguished from the other case, and therefore they were admissible. The respondent appealed, and the EAT agreed with the tribunal and said that the judge had properly balanced those competing interests between the relevance of the evidence on one hand and the public interest in preserving confidentiality of private deliberations on the other. And then we'll move on to another case which actually says something quite similar as well. And again, it is a case where the employee brought claims, I think, of disability discrimination and unfair dismissal. In support of his claim, he wanted to rely on an audio recording he'd taken during a disciplinary hearing of conversations which took place between internal panel members during his absence. Theme here, isn't there? The tribunal at that, in the first instance, said actually no, can't rely on this. They were private stroke legally privileged, but didn't really give a proper explanation of this. The employee appealed and said that legal professional privilege hasn't been established, and the judge should have actually considered the contents of the recordings he wanted to disclose. So what did the EAT do? Well, they did consider legal professional privilege, and they decided that the references in the recording to advice given by the solicitor of the employer and the contents of the conversations where the panel's discussing this legal advice were privileged, so not admissible. So that's helpful. But obviously they then looked again at the public policy aspect of the rest of the discussions. And they found the legal position to be that, again, the fact that the evidence of the private deliberations of an internal panel was a product of a covert recording was not in itself enough to render it inadmissible. There's an important public interest in preserving the privacy of deliberations, obviously for this full and frank discussion of the issues. Balance has to be struck between this public interest and the public interest in, obviously, a litigant being able to have all the evidence before the tribunal. And we need to consider the particular circumstances of the case. In this case, there was a strong public interest in preserving the privacy of the panel's discussions. But actually what happened is that the employer had listened to what had been said in the breaks and then told the employer that they knew what happened. And then the employer, using this information, decided to dismiss the employee. So, of course, the recordings are very, very relevant. And the tribunal said that actually the decision to dismiss couldn't properly be assessed without listening to these recordings, and therefore they were admissible. But, of course, they did say that those bits that are covered under legal professional privilege weren't. It's kind of moving in one direction for me.
Yes, it is, isn't it? But it seems to me there's a practical solution to all this, which cuts through this, isn't there? Which is either, if you're a panel, move to another room, or at the very least, do a search of the room before you start your deliberations to make sure there's no recording device.
Yeah.
I suspect position would also be improved if you'd actually said at the beginning, we don't permit any recordings
Exactly.
of this.
You're setting the ground rules.
So maybe we'll just put together some standards in the scripts we give to clients, which just add that, and then add at the end of the meeting, check the room.
Yeah, we'll make sure you've got 2 rooms booked for your meeting.
Yeah. So there we are, and that brings us on to data protection. Now this is it's an interesting one, which is not a phrase you often hear with regards to data protection, unless you're me. But it's a developing area, and I think which is potentially quite fruitful for employers, because I think there is a really valid question to ask, which is, if an employee is going to record a meeting, does that make them subject to the Data Protection Act, GDPR? Are effectively they becoming a data controller? Here's the definition of data controller. It's a natural or legal person, so natural people are all of us, believe it or not, public authority, agency, etc., which alone or jointly with others determines the purpose and means of the processing of personal data. Now, what's personal data? Well, personal data is any information, particularly digital information, and the stuff recorded on a mobile phone is, of course, digital, about a person. So clearly, when you're recording, you're going to be capturing personal data. It's going to be personal data of the other people in the meeting. It's going to be the personal data of anyone who is discussed during that meeting. They're all going to be identifiable for it. So clearly, there's personal data there. So does that mean that the employee can be a controller? Well, an employee may argue that they're not, because of one of the recitals, which appears to exclude certain types of individuals from being data controllers. The regulation, GDPR, does not apply to the processing of personal data by a natural person in the course of a purely personal or household activity. Personal or household activities could include correspondence, the holding of addresses, or social networking, and online activity undertaken within the context of such activities. Now, this excludes the stuff you post on Facebook. It excludes the fact that you might have on your fridge door a list of all the household tasks that each member is going to be undertaking during that week. It would exclude the text messages between you and your other half, etc., looking at who's going to pick up the milk on the way home. All of that stuff is excluded. I don't think this excludes, however, recording a conversation, covertly or otherwise, in the context of a disciplinary grievance, because I don't think it can be said to be purely personal or household. I think it's professional. So I think that if you are, as an employee, recording, then all of a sudden you become a data controller for the purposes of GDPR. There's a bit of support for that in the Morrisons case. You'll all be aware of the Morrisons case, which is the one where Morrisons is potentially pinned with liability for the actions of a rogue employee. And one of the things that judgment found was that the employee, when he had been misusing the data, he wasn't an agent of Morrisons. He was a data controller in his own right. So I think that's good precedent for the fact that an individual can be a data controller. We then have to ask ourselves, what is the personal data that controller has got? And as I said earlier, it really is, it's the fact that, they're sitting there in the disciplinary and they're blaming Joe Bloggs for having stole the petty cash, and it's not them. They are sitting there discussing why someone in the accounts office would make up allegations that they sexually harassed them. All of that stuff is personal data, as is the fact that the interviewer, the HR manager, the manager holding the disciplinary, is sitting there talking. All of that's personal data. So all of a sudden, your controller is the employee, and your controller has obligations. And I think they do have a number of obligations, and this is where we start to get into maybe some of the more weird and wonderful ways in which data protection works. Because what are they meant to do? Are they meant to sort of give you a privacy notice, a transparency notice, sort of setting out your rights as their data subject? Well, arguably yes. Certainly, I think what they must do is inform you very early on that they have that data and they are processing it. And certainly, I think if someone was to wait until the doors of the tribunal before saying, aha, here's my iPhone and look what I've got recorded on it, then I think you'd be within your rights to say, how very dare you, I'm going to report you to the ICO. How the tribunal would deal with that is another matter. But I certainly think it's there. And I think it's something which we should be potentially reminding employees of, and we can look at this when we look at perhaps what we do about all of this. But I think employees need to understand that they have obligations in this field, and they don't just have carte blanche to record. Also, under data protection, what are your obligations as an employer? Well, of course, as soon as you have a copy of that recording, then it is your data, and that's when it needs to be processed in accordance with the provisions of the Data Protection Act 2018, GDPR, etc. So it does become data and must be used as such. Clearly, if it's going to be used in the context of litigation, then there are certain exclusions from data protection legislation with regards to that. But overall, that's going to be your data. And of course, as soon as they have provided it to you in a copy form, then it is data which you are processing because you're storing it. Now, here's the question. What happens if they've covertly recorded it on a work mobile phone? Who does it belong to then? Who has the responsibility? Well, bizarrely, I think you're probably joint data controllers and you both have obligations. But that's perhaps one for another day. But I think the point we have to have here, and of course it's a developing field, is that there are data protection obligations on the employee in this area. So I suppose that begs the conclusion. What do we do? Clearly, it's an increasing issue with technology and with people's perceptions of how they can or cannot sort of keep a running commentary on their lives and what they do with that. I think it does make sense to set out what your position is. We can't stop someone from covertly recording something in spite of what you have told them. That's just human nature. But certainly I think you could have a policy in place saying that employees are not permitted to covertly record, that it is a disciplinary offence. I suspect it's not gross misconduct, but I think it can be there as a serious misconduct, can't it? And also to make that clear in any policies or procedures you've got with regards to the conduct of meetings, conduct of disciplinaries, anything else. So I think, making it clear is really important. Building into your disciplinary policy. Again, anything else we should be?
Well, I like your suggestion of another room, or at least get the employee to stay in the room and you go to another room and record themselves.
I think it is those practical things.
And just at the start of each hearing, just perhaps making clear that actually this is how the meeting's going to be recorded. We haven't got any recording devices, especially you don't have any. But it's very difficult, isn't it? Because, employees will be naughty. Absolutely, we can't. And I think probably the other thing is not to panic, because again, it's one of these areas where we receive a voicemail message from a client saying, I need to talk to you urgently, and you call them back and it's, oh my god, this is something which I need to talk to you urgently about because I've just found that so and so has got a recording, or they're saying they've got a recording, and we've got to do something about it now because this is going to be disastrous and all the rest of it. And actually it rarely is, particularly given the fact that 99 times out of 100 the recording will not disclose anything the employer has said, which shouldn't have been said. So I think it's a case of don't panic. Keep
calm and carry on. That well-known phrase. I expect we'd be done for copyright now. I hope you found that interesting. Any questions, then please do get in contact with us. We'll be happy to deal with them. And any suggestions for our next webinar? Maybe we could find a way of doing covert conversations, covert recordings part 3.
I know, I was just thinking that could be a part 3, but I'm not quite sure I've got the imagination to think that one.
But we'll see. But